My Lords, we were looking at the facts going to the judge's core finding on actual constructive knowledge. I'm going to take these points very quickly, just by reference to the table. So we were up to point 6 on the table, so if you have that to hand. The fact that based on the information he gave to Betfair, the claimant could afford his gambling from his income and assets. This point was addressed in detail by Mr. Davies-Jones in his opening remarks this morning. There's not really any issue between the parties that the claimant could afford in the sense of paying from his income and assets together, the gambling, that his losses. The only question or the only point raised is what is meant by affordability and whether it's legitimate for Betfair to take his wealth, some of the income from his property sales into account, and we say that it was.
Well, the point is the one that I made this morning, isn't it? If somebody was incredibly wealthy in terms of capital but didn't actually have any income, it doesn't mean they're still not wealthy and they can't afford to gamble.
Exactly.
If they have to sell capital investments, well, so be it.
That's exactly the point. And until sort of looking at until you know the detail of the customer situation, it's impossible to come to a sort of a hard and fast rule on that. So point 7 is the fact that the claimant took steps to actively hide his gambling problem and to portray to the world at large and to Betfair that he was comfortable with his gambling, could afford his losses. And there were really sort of 3 elements to the evidence that underlie this finding. There was the evidence of the claimant's account manager, Mr. Stuart Rourke. There was the claimant's responses to the responsible gambling interactions, some of which were with Mr. Rourke, some of which were with other operatives within Betfair. And then thirdly, there was his response to the AML EDDs, where he was assuring Betfair repeatedly that he could afford his losses. And I just want to emphasise the first of those points, so the evidence of the account manager, Mr. Stuart Rourke. And there are some references on the table. I won't take you to it, but I would invite you to look at those. So in particular, paragraphs 46 to 48 of Rourke 1, and 9, 13 and 29 of Rourke 2. And essentially what Mr. Rourke says, now Mr. Rourke was a reliable, impressive witness who the judge found took his role and responsibility very seriously. And ultimately what he says at the end of his second witness statement is, I've read Mr. Gibson's witness statements in these proceedings. I'm concerned by it, but I'm also very surprised by it because this doesn't reflect the man that I saw at the football matches. This was not my impression of him at the time.
No.
And so the next point over the page is the fact that it's very difficult to identify a problem gambler, particularly one who's not being honest, even if you have access to data about their account. And again, Mr. Davies-Jones made this point this morning in opening, particularly by reference to the expert evidence, which have the references there on the table. The point I just wish to emphasise is that the witness evidence from Betfair also strongly reinforced that conclusion. In particular, Ms. Lawson's evidence couldn't have been clearer. But actually doing this in practice is very, very difficult. So turning then to the facts that the claimants say undermine the judge's findings on actual constructive knowledge. As a global point, I think it's important to distinguish between what might be a potential indicator that someone may be at risk of being a problem gambler, and the fact which puts you as an operator on constructive notice that they are a problem gambler or that they are likely to be a problem gambler. And so many of these factors, such as the amount of losses, for example, no one's saying that that's irrelevant to the kind of responsible gambling policies that Betfair has in place. But what it is, it's a potential indicator that you should ask more questions. It's not a fact that puts you on notice that someone's a problem gambler. So the first point on my table under this heading, point 9, was I think the 6th point raised by my learned friend. He emphasised the fact that the psychiatric experts agreed that the claimant clearly has a gambling disorder. And this was covered in the exchange between Lord Justice Popplewell and Mr. Davies-Jones this morning. It's also reflected in 125 of the judgment. And the simple point here is that the fact that after the event, Mr. Gibson could sit down with a psychiatrist at a time when his gambling problem was in remission, and reflect and look back and answer questions in such a way that a psychiatrist could say, yes, I can see you had a gambling disorder based on the information you're telling me. That's a million miles away from saying that Betfair, on the basis of the information it had, could have identified at the relevant time that Mr. Gibson had a gambling problem. And as I say, the judge makes that point expressly at paragraph 125 of his judgment. Fact number 10, which I think was my learned friend's second point, is the level of losses. In paragraph 73 and 74 of the judgment, the judge refers to evidence he heard from Betfair's witnesses, where they said the amount of losses on their own do not tell you whether someone's a problem gambler. You have to know more about the context. And there are some underlying references to the evidence there. The next point, whether or not the fact that the claimant was selling or mortgaging some of his buy-to-let properties put Betfair on notice. This overlaps with the same affordability point, and again, it's already been addressed. And the key point here is that although you might be able to say at a level of abstraction, or in a very general sense, that selling or remortgaging, selling or borrowing, I think is how it's put, might be a sign that someone might be experiencing problems. The real question is, well, what was being sold, what was being remortgaged in relation to this case, on this fact pattern, and did that put Betfair on notice that the claimant had a gambling problem? And it didn't. So turning over the page, point number 12, which I think was my learned friend's third point, relates to the number of bets. And just to draw your attention here, so Lord Justice Birss, you asked a question in this context of, well, what is a normal number? If you're a gambler, is 5 bets a day a normal number of bets to place? And there was some evidence from Mr. Rourke on this, paragraph 49 of his witness statement. Again, I'm not going to turn it up, but just for context, what he said was, yes, so he said that the frequency and number of bets placed by Mr. Gibson were not unusual or particularly high, and that many of his customers, admittedly he is talking about a cohort of VIP customers that he managed, and his evidence was that many of his customers would place hundreds of bets in a day, or would bet most or every day. So that provides some context to the frequency of bets placed by the claimant. Point 13, which was my learned friend's fourth point, is the fact that the claimant was frustrated when his account was suspended for the AML check. Again, my lords have made the point, the frustration in itself in this context might not necessarily be a particularly strong indicator of problem gambling, because you have to know why is the customer frustrated. And again, Mr. Rourke explains that it's very common, in his witness statement, he explains it's very common for customers to get frustrated when they're asked about AML information. And Mr. O'Keefe, who's a responsible gambling analyst at Betfair, his evidence was that he'd listened to this particular call in question. So he'd been asked to listen to this call where Mr. Gibson is frustrated about his account being suspended. And he said, I see no red flags here. There's nothing that concerns me as a responsible gambling analyst when I listen to this call. Point 14 relates to the point that the claimant had placed some bets on some off-school football matches. I'm not sure that point was raised yesterday, but the evidence in response is that the gambling pattern of Mr. Gibson is in fact very consistent. And finally, the chasing losses point. So it said that Miss Lawson, except this is very easy, it's easy to identify whether a customer is chasing losses. Mr. O'Keefe, in fact, thought it was quite difficult. And ultimately, in terms of the evidence, where we got to is it's working out what chasing losses really means, as distinct from continuing to bet after you have lost money, is not entirely clear. So for all of those reasons, we say that the judge was right, and certainly not wrong, to find that Betfair neither knew nor ought to have known.
Thank you. Thank you very much. Yes, Mr. Davis.
Well, it's ground of appeal 2, negligence. I'd like to start with Calvert, if I may.
Yes.
So starting with duty. Calvert is in Authorities tab 17, and it's at page 513 using the internal bundle numbering. Bundle Authorities 1, Right, paragraph 2, which begins on the next page. Can I just ask you to read para 2 to yourself, the quote from Reeves and also the paragraph immediately below? So right at the start of Lord Briggs, but Mr. Justice Briggs as he then was, right at the start of the judgment, that the judge is making clear the importance of the principle of autonomy, of adults of full mind, full age and sound mind taking responsibility for their actions. That does not, of course, mean that duties of care in respect of self-inflicted losses can't arise, but it does mean that such duties are exceptional. If we turn forward in the judgment using your hard copy bundle numbering to page 547.
Could you just give me paragraph numbers?
Para 127.
127, thank you.
I'll do the paras if that's easier.
Yeah.
Para 127, the judge finds in the first sentence that Mr. Calvert had become a problem gambler by the beginning of 2006. And in order to make that finding, the judge on Opus, we're in AU tab 17. In order to make the finding that he'd become a problem gambler by the beginning of 2006, what the judge did is apply the DSM-4 criteria, and he finds in 127 and 128 that Mr. Calvert satisfied 3 of them.
Yeah.
And then over the page at para 129, the judge finds that he'd become a pathological gambler by May 2006. Now, when the judge uses the term pathological gambler, he's describing what we would now describe as a gambling disorder under the terms of DSM-5. But at the time it was DSM-4, pathological criteria, and he makes that finding because he says by May 2006, 2 more of the criteria in DSM-4 would have been satisfied or were satisfied. And then at paragraph 1, at paragraph 134 over the page, he finds in the first sentence that Mr. Calvert had become a severe pathological gambler who had lost control of his gambling during the last quarter of 2006. And I pause there just to note that in our case, Mr. Gibson's gambling disorder, as found by the judge, never reaches the stage of severe. At all times, it's a moderate gambling disorder. At paragraph 136, at the bottom of that page, the judge's analysis of duty of care begins. And over the next couple of pages, 2 or 3 pages, he sets out the principles of English law. And if we go to paragraph 151, which is on page 553 in the hard copy, so para 151, the judge concludes this section by saying, these and other cases show that exceptional circumstances may give rise to a common law duty of care to prevent or to mitigate the consequences or aggravation of self-inflicted harm. Such circumstances may include the assumption of control over a person while vulnerable to the consequences of self-inflicted harm, or the assumption of some responsibility for the care or the provision of assistance to such a person. In every stage, in every case, the 3-stage test will be an important part of the analysis, whether the circumstances are sufficiently exceptional. That's his analysis of general principle under English law. He then turns to consider some Australian cases. The one he seems to regard as most significant is a case called Reynolds, which he deals with at para 156 and following. in the Reynolds case, as we can see from 156 in the third line, the trial judge had found that the defendant, who was a gambling club, knew or ought to have known that the plaintiff was a problem gambler, but nevertheless dismissed the argument for a duty of care, and held that mere knowledge that the claimant was a problem gambler wasn't sufficient. And one sees, I think, the reason why in 157 the plaintiff's gambling problem was insufficient to prevent him from retaining both full responsibility and sufficient control over his urge to gamble. See in particular those pages culminating in this rhetorical question. Even with knowledge of problem gambling, how is the club to know, when asked to cash a cheque, whether the anticipated gambling is the unwanted but compulsive craving of a problem gambler, or the choice of a sometime problem gambler, then in control of his indulgence? And that's an idea that Mr. Justice Briggs returns to a few pages later in the judgment. Having dealt with the Australian authorities, the judge then summarises the parties' arguments from 163 to 166. As my learned friend told you yesterday, there was an argument for a broad duty of care owed to problem gamblers, and there was an argument for a much narrower duty of care owed to Mr. Calvert specifically because of the promise, essentially, to self-exclude him. Dealing with the broader duty, which is the one that's relevant for our purposes, the judge's analysis begins at paragraph 167. Attractively, though it was put, I've not been persuaded by Miss Day's broader submissions. Its essential features were the identification of a duty of care to problem gamblers as a class and a legal obligation to take care in the application of every aspect of William Hill's social responsibility policy and procedures in respect of any customer reasonably identifiable as falling within that class. 168 says, I'm not persuaded that by developing its own social responsibility policy and procedures, William Hill can be said voluntarily to have assumed responsibility to all its problem gambler customers in the sense of assuming responsibility to take care with a concomitant liability to compensate customers injured in their mind or in their pocket by any failure to take care. Now, just pause there. Of course, in this case, the social responsibility code obligations are not voluntarily assumed by us, they're imposed on us by statute, but that won't assist Mr. Gibson on his appeal. It's common ground that breach of the social responsibility code obligations does not in and of itself give rise to a claim for breach of statutory duty.
Well, that's section 24.8, isn't it?
And that's reflected in 24.8, exactly. The imposition of a statutory duty does not in and of itself give rise to a common law duty. If a common law duty is to arise out of performance of a statutory duty, it must arise by the application of ordinary principles, i.e. conduct equivalent to an assumption of responsibility, and only if that would be consistent with the statute. Now, those last two propositions I've given you, after my Lord Justice Flo raised the point about section 24.8, what I said after that reflects the reasoning of the Supreme Court in the Poole case at para 65. And I should say also para 70 to 72. If a claim amounts to no more than saying the defendant breached a statutory duty in circumstances where the statute itself gives rise to no private law right to sue for breach of statutory duty, then a common law duty would be inconsistent with the statute. I wasn't going to take you to Poole, but I'd be happy to do so if the court wanted me to after Calvert. But as I say, the source for those propositions is Poole, paragraph 65 and 70 to 72. So if we come back to Calvert and we turn the page, the judge sets out his analysis of why no broader duty to problem gamblers as a class is owed. And at paragraph 69, he says he's not persuaded that it can properly be said of problem gamblers as a class that they uniformly suffer from such an impairment in their ability to control their gambling that it would be proper for the law to treat them without more as being so vulnerable as to require special treatment even in the absence of a request for it. And exactly the same point applies in our case, and in exactly the same way it cuts against Mr. Gibson's alleged duty of care. What is being alleged in our case is a duty of care said to be owed to a subclass of the cohort of problem gamblers, i.e. those who were, quotes, actively managed, close quotes. But that narrowing of the cohort is one of forensic convenience only. It doesn't answer the point that Mr. Justice Briggs makes in the first sentence of para 169, because problem gamblers cover a broad spectrum of gamblers, and it's only problem gamblers at the extreme end, i.e., as we shall see, severe gambling disorder who've lost control, that are sufficiently vulnerable so as to enliven or give rise to the need for a common law duty. So we say amen to paragraph 164 of Calvert, and the same applies in our case. Paragraph 170 is the second reason the judge gives. He says, secondly, I'm sorry, could I, forgive me.
The fact that problem gambling can be more or less severe does not of itself determine or militate against the duty being owed in respect of all who come within the category, does it?
I agree with that as a matter of principle. What the judge is saying here is that with respect to the width of problem gambling, that at the non-extreme end, it isn't severe enough to come within the place on the spectrum where the law would impose a duty of care.
Yes, but I didn't follow any reasoning for that.
I skipped over the second sentence of 169. The psychiatric evidence before me shows, as it did in the Australian cases, that problem gamblers range across a wide spectrum from loss of control at the extreme end to experiencing merely difficulties in controlling their gambling at the opposite end. So that's the wide spectrum point. What he said in the first sentence is that the width of the spectrum means that at the non-extreme end, the need or the vulnerability is not sufficient such as to enliven a common law duty of care. And all of this has to be placed in the framework of principles that he spent some time setting out through the paragraphs that I perhaps skipped over too quickly. But I mean, the issue here is that one is concerned with self-inflicted financial loss. One is concerned with loss for which the gambler in the normal course should take responsibility as a person of sound mind and full age. Yeah. The question is, at what point, given that, at what point does the gambling operator find itself in a position where it is actually underwriting the gambling of the gambler? Yeah. And as we see from Mr. Justice Briggs's judgment, and I'll take you through the paragraphs now, but he says, well, yes, that might be possible, but it has to be at the extreme end. Because that is, otherwise you are, for example, not giving full respect to the principle of autonomy. And you're not giving full respect to some of the other points which he comes on to mention. So if we look at paragraph 170, he says, secondly, while there is a subclass of problem gamblers, namely pathological gamblers, for whom it can properly be said that control of their gambling has become impossible, It seems to me wholly unrealistic to suppose that in the ordinary course of its business, a bookmaker can be expected to be able to identify that subclass by way of what amounts to a process of medical diagnosis. Although in the present case I've been persuaded that the claimant has become a pathological gambler by the end of May, it was no part of the claimant's case that William Hill knew or ought to have known that he was within that class. I'm going to come back to the last sentence in a moment.
But isn't that, I mean, that is one of the ways in which it's said against you that this case is out of date, because the modern methods of data collection available to people like your client overcome that lack of knowledge, and that's what's said against you.
Yes.
I appreciate this is all on the hypothesis that you knew or ought to have known, and we've heard Miss Tulip on ground one, and of course if you're right about ground one then none of this arises anyway, it's all academic. But on the assumption that you did know or ought to have known, this particular passage is not really apt, is it?
Can I read you the last sentence?
Yes.
Before I come back to your question?
Of course you can.
Can we read it together, I should say?
Yes.
Accordingly, the judge says, while it may be that the broad duty of care alleged by Miss Day may arise in relation to a customer whose behaviour has become so extreme as to demonstrate to a bookmaker that his gambling is wholly outside his control, that possibility does not avail the claimant in the present case. So just pausing there, I mean, one of the things that's very interesting about that last sentence is that the judge conspicuously avoids using the language of constructive knowledge. What he does is he fixes the trigger point, the flip point, if you like, between no duty and duty, at a place on the spectrum where the behaviour unambiguously communicates and would unambiguously communicate to anyone that the gambler was completely out of control. Just pause there, if I may. On the facts of Calvert, Mr. Calvert had lost £2 million in 6 months. What the judge says at the end of this last sentence is that the possibility he's carving out, the safe harbour, he says doesn't avail Mr. Calvert in this case. So there's absolutely no doubt that what the judge is talking about in this last sentence is really, really extreme. And in my respectful submission, he's absolutely right to place the trigger point at that point in the spectrum. And if that's the question you're pushing me on, I think he's absolutely right to do so, because it reflects the importance that the law attaches to the principle of autonomy. It reflects the fact that duties of care in tort for self-inflicted losses are exceptional. It reflects the fact that in this example, he's giving...
It's really the case of the person who can't help themselves, literally
Exactly.
can't help themselves.
That is exactly...
And the bookmaker knows that they can't help themselves, or it's quite apparent that they can't help themselves.
That is exactly it. He's on the one hand, he's dealing with a case where the gambler requested help. He asked to be self-excluded. Yeah. That's obviously a situation where the gambling operator is completely on notice that there's a problem. But in this last sentence, he's dealing with a situation where there isn't a request for help. Where is the point where the vulnerability and dependency, I think those are two sides of the same coin, is so obvious that no gambling operator can, as it were, not underwrite the gambler's gambling thereafter.
Yeah. Underlying this submission appears to be that the duty we're examining, the existence of which we're examining, is not a duty to take reasonable care, but a duty to exclude. But it isn't. We're talking about the existence of duty to take reasonable care, and that may involve a range of different steps, depending on how the problem presents itself. And if someone has something which is below the level of a complete loss of control, but still a very obvious impairment of control, then the exercise of reasonable care to prevent losses may not require exclusion. But to say that there's no duty at all, so that they're simply the class of those to whom the duty can be owed are those who have obviously completely lost any control, puts all its eggs in the autonomy basket, doesn't it?
No, it does pay due weight to autonomy. I absolutely accept that. I also agree with you that the analysis has assumed right from the start of the judgment that it's dealing with self-inflicted losses. And although the judge doesn't use this language with a failure to make the position better, doesn't use the language of failing to confer a benefit, but the Calvert case, of course, as indeed our case, the Calvert case, the gravamen of the complaint was that you should have shut me down. You should have shut me down. That's the essence of the complaint. There was interesting debate in court yesterday about whether that goes to the nature of the duty or nature of the breach, etc. For my part, I quite see that these questions, the question in particular you've just put to me, is a characterisation question, and like a lot of characterisation questions, reasonable views could differ on it. But the gravamen of the complaint here is that you failed to make things better by not shutting me down, and for what it's worth, I would say that the characterisation given by Mr. Justice Briggs is the right characterisation. I would also say that I don't think that's going to make it any difference, that this question of characterisation, in my respectful submission, shouldn't make any difference to the outcome of this appeal. But I think, I mean, just if I think...
I understand that, but that may be a breach question rather than a duty question.
Maybe a causation question. Or
causation question.
Yeah.
But at the moment, we're just on the duty question.
Yes, no. But the duty question is of interest, obviously, and although I'm mindful of time, can I just come back to this issue of why the trigger point should be put at that place on the spectrum, at this extreme end place of the spectrum? I think doing so has a number of advantages. I mean, in the first place, it allows for the difficulties that arise from an absence of a request for help. I mean, we're all looking at this in the context of a case where, you know, years after the event, the gambling customer has come forward and said, I had a disorder. You didn't do this. You didn't do that, etc. But imagining yourself in there at the time, looking at your, I mean, I think, you know, Betfair, I'm not sure this is in evidence, but Betfair has about 500,000 customers. So, you know, looking at your customers, you know, at the time, you know, what is it to make you stop, to make you you know, think, and in the absence of a request, it is difficult, and there was considerable evidence before the judge, which the judge accepted, that you can't diagnose problem gambling by data alone, that you have to speak to them. So if we're just focusing on behaviour, in the absence of a request, it does need to be very, very extreme behaviour. Putting it where the judge put it allows for variation. And there's a basic point which flows through a number of the Gambling Commission documents, and certainly the evidence the judge heard in this case, that what is problem gambling for one person is not for another, is excitement, is professionally managed, is whatever it is. But there is enormous variation from person to person. So again, if you put the trigger point at the top, you know, towards the top end of the spectrum or at the extreme end of the spectrum, you are allowing for variation. And it's also allowing for the fact that customers, as in this case, may not tell you the truth when you do interact with them. So,
I'm sorry to interrupt you, but
no.
The duty we're examining is a duty which is framed by reference to customers who it is known, or it ought to be known, in fact in this case it said is known, are problem gamblers. Now, if there is a difficulty in proving in any given case that was known or ought to have been known to a betting company, so be it. Then the duty won't be engaged. But it's illogical, isn't it, to say, well, just because there may be difficulty knowing, in cases where it is known, no duty can arise.
Well, I think the know or ought to have known is a very convenient shorthand which gets used, you know, in lots of different circumstances throughout the law, but it's two very different mental states.
Yes, it is, that's a fair comment.
And the mental state you've just put to me is no.
Yes.
And if you know someone is a problem gambler, you've got to shut him down. That's a matter of...
Not according to Mr. Justice Briggs, only if he's right up at one end of the spectrum of problem gamblers.
Well, this is a question of duty of care, yes. But again, I mean, you're juggling different principles. Problem gamblers as a class. I mean, okay, say you know someone is a problem gambler, but you know, where in the spectrum of problem gamblers is that person? I withdraw what I just said about if you know someone's a problem gambler, you've got to shut them down, because this comes back to paragraph 169. You know, where on that very broad spectrum is this person? You know, if he's at the extreme end, and obviously the debate is whether, you know, Mr. Justice Briggs has put the trigger point in the right place, or whether it should come slightly further back this way. But if he's at the extreme end, that's one thing. If he's at the end where he's perfectly capable of controlling what he's doing, it's just that he also, you know, occasionally gives in to indulgence, then absolutely not. No, I mean, we had the debate right at the start about the difficulties of knowing what is a problem gambler. And again, that's another point that Mr. Justice Briggs's location of the duty of care trigger point on the spectrum accommodates, because there isn't any doubt in the example he gives in the last sentence, because he's framed it in that way. And I do come back to this point again. It is conspicuous that the judge does not use the language of constructive knowledge. I think what he's talking about here is an unambiguous communication, something which permits of no other conclusion. And in my respectful submission, that is putting the trigger point in the right place.
It's a forward constructive, isn't it? The sentence isn't talking about what the bookmaker knew, it's talking about what the behaviour demonstrated to the bookmaker. So it is, in that sense, put in an objective way relevant to the behaviour rather than anything to do with the mind of the bookmaker.
I mean, I find the word demonstrate significant, because I think it doesn't say indicate. I think it says demonstrate. I think that conveys the sense of unambiguous communication. And what is it that's being unambiguously communicated? The gambler is wholly outside his control. And did that avail Mr. Calvert, who'd lost £2 million in 6 months? No. So it's if I had to, I think what it's getting at is a form of actual or otherwise blind eye. I don't think it's getting at ought to know. And I don't think it would be right to get at ought to know, because I think the danger with ought to know is that in isolation and taken out of the context of this very sophisticated analysis which the judge gives in Calvert, it's setting the trigger point too low. I think I probably said as much as I possibly can on that subject. Can we read on?
Yes.
So we've done 170, 171. In one sense is a point specifically to do with William Hill's social responsibility policy, because it was designed to operate in such a way that any gambler offered self-exclusion would be required to acknowledge by his signature an express disclaimer of legal liability for the consequences of any gambling while excluded. But interestingly, at the bottom of that paragraph, the judge, in the last 4 or 5 lines, the judge refers to the Gambling Act. He says the Gambling Act, which was then shortly to come into force, provided that compliance with licensing conditions designed to assist problem gamblers was not of itself to create legal liability, and that's obviously a reference to section 24.8. And the Commission's own policy has thus far been to permit liability exclusions as complaints with the licensing regime. That might be a convenient point to answer my learned friend's submission yesterday, that Calvert is legally out of date. I think that's the way he put it. And I think the reason he put it, or what he said, was because it's been superseded by the Gambling Act.
Yeah.
So there are 2 points about that. The first is it's perfectly true that the decision in Calvert preceded the Gambling Act, or the events anyway, preceded the Gambling Act coming into effect. But the case took place, obviously, after it had been enacted, and many years after the White Paper. And it's perfectly clear from 171 that the judge has the Gambling Act well in mind. That's the first point. The second point is this. I think the real point that my learned friend seems to be making is that it's somehow legally out of date because the judge doesn't recognise, and this I think goes back to 169, he doesn't recognise that, quotes, vulnerable persons are recognised in the Gambling Act as deserving of protection. And in my submission, that is confusing different concepts of vulnerability, simply because, quotes, vulnerable persons for the purposes of the Act should be protected by the Social Responsibility Code pursuant to the Act. It doesn't mean that any and all such persons fall into the category of vulnerability that will enliven a voluntary assumption of responsibility.
Yeah.
And that takes you back, I showed you on the way, paragraph 151 of the judge's judgment, where he talks about the exceptional circumstances where duties of care can be imposed, but what they have as a feature is some very high level of control over the individuals concerned, or some voluntary assumption of responsibility to look after them. So I don't accept the label that it's legally out of date at all. I don't think I did deal with the technologically out of date point. Can I deal with that? It's obviously the case that technology has moved on enormously since 2008, when the judgment was handed down. Technology today is not the same as technology in the years 2015 to 2019, which is what this appeal is concerned. The judge heard evidence, and on the basis of that evidence, he concluded that in the relevant period, it was very difficult by data alone to identify a problem gambler, and impossible if they weren't going to tell you the truth. Data can get you to a point of interaction, but if they don't tell you the truth, it doesn't help. Now, what you are not having to decide in this appeal is what the position is as regards data and data capture and data analytics today, and I personally have absolutely no idea. But this case has to be disposed of on the basis of the evidence.
I'd be surprised if it were any easier to identify a problem gambler, even with the technology now available.
Well,
because it's such a subjective issue, isn't it?
Absolutely.
As those 9 criteria, or 8 criteria, how many it is, identify, as you said this morning. 5 of them are as it were, internal mental issues, aren't they? And if the gambler isn't telling the exchange, the betting exchange, that he's got a problem, I'm not sure how they do pick it up.
I absolutely agree with that. That was going to be my final point, but I was just taking the precaution of cauterising, if you like, 2015 to 19 from the issue of whatever data can do today. Okay. But that is my final point on it. Lord, yes. The judge turns to the 3-stage test at 172. He accepts foreseeability. He at the bottom of the page, he doesn't find proximity. In my judgment, the law should be very slow to recognise a sufficient proximity to justify a requirement to take protective steps to restrain a gambler from exercising his liberty to gamble on his own responsibility, where his status as a problem gambler may mean no more than that he's experiencing mild and occasional difficulties of control. And we say amen to that. And again, he emphasises he's dealing here with all problem gamblers, regardless of whether or not they have sought assistance. And now my learned friend's response to that yesterday is to say, well, don't worry, we're not talking about all problem gamblers, we're talking about all problem gamblers who are actively managed. And when pushed about that seemed to be a description of people who are more intensively marketed than normal. And my Lord Justice Popplewell then asked the question, well, you know, by what criteria do you decide whether you're in the more intensively marketed category? At what point do you shift from this and that? And to which there wasn't an answer. And that's another reason why one has to tread so very carefully in this area. And ultimately, it is sound policy to stand on autonomy and the individual's liberty to gamble, as the judge does in paragraph 172. And then in 173, he says it wouldn't be fair, just, and reasonable, because he says, as Mr. Fenwick submitted, it would place a burden on the bookmaker pursuant to which the problem gambler could freely take home his profits, but look to the bookmaker for the return of his losses without even seeking the bookmaker's assistance. That's the no request point to help him control his gambling. So it's not fair or reasonable, essentially because it would or could promote risk-free gambling for gamblers who have not even sought help. And we say amen to that. Exactly the same applies here. Can I mention one other point under this context of unfair and unreasonable, or fair and reasonable, which is that we are a betting exchange. We make our money because we charge a commission on winning bets, but we're not counterparties to the bets. No. So that Mr. Gibson's losses are not monies that we have received. We didn't win those bets. We just charged a commission. And that's another, in a sense, that's a much more, puts us in an even stronger position, or it would be even more unfair for us than for William Hill on that basis. My Lords,
I'm not sure I've understood the point. I think I understand the point, but I think the commission you referred to, your client's commission is on the winning bet.
Yes.
You don't take a commission on the bet that's put down. You take a commission when the winner wins.
I'm so sorry, my Lord, I didn't hear that.
So if I bet £1 on something happening, you get the commission if it happens, and the £10 is paid out for the sake of argument. You take a commission on the tenner.
We get paid commission by the person who wins that bet. So we just provide the exchange, the room in which willing backer and willing layer meet. And yeah. Calvert went to the Court of Appeal, as you know, but on causation, which we'll come to. Calvert has been referred to, I think it's fair to say, with approval in my Lord the Chancellor's speech in the case of a rent-true and against IG Index.
Yeah, it was on a slightly different point. I had another look at it the other day.
I'm grateful.
I didn't see anything in it that was really of much assistance, to be honest.
No. And I mean, I think you just referred to it as an instance of a duty for self-inflicted losses being exceptional.
About spread betting from recollection.
There are two cases in the bundle, Ritz and Al Daher at tab 24 and Ritz and Al Jibari at tab 25. First instance decisions where the principles or Calvert was treated as stating the relevant principles, but no duty of care was found. I think that is all I would say about Calvert and the law in principle. If we then just turn to the application of the law and the way the judge dealt with this. Paragraph 156. The judge sets out the duty which was contended for at trial. it was a duty to prevent financial loss to Mr. Gibson as a customer who was being actively managed and whom Betfair knew or ought to have known was a problem gambler, alternatively likely to have a pathological gambling disorder. So that's the bit of the duty that has dropped off, or the duty contended for that has dropped off in this appeal, because the duty that's contended for before you is just where Betfair knew or ought to have known that he was a problem gambler. Before we see the reasoning, it's worth mentioning that originally there were two other factors that were relied on as enlivening the duty. The first was said to be, in the pleadings, was said to be an express term in the terms and conditions that the Social Responsibility Code would be complied with. That part of the case fell away very early on. It fell away in the reply. That left an argument that there were implied terms in the terms and conditions, that there was an obligation assumed by Betfair. And the judge found against him, and there's no appeal. So by the time the judge,
it's all negligence or nothing, isn't it?
yes, but I think it does help just to have in one's mind that by the time the judge got to duty of care and tort, he had already found that there was no contractual assumption of responsibility. And then he sets his reasons out 163 and following. And in particular, he focuses on the allegation that we knew or ought to have known that he was a problem gambler. And he answers that at paragraph 164. And the answer he gives to that at paragraph 164 very much flows out of the findings he'd already made at paragraph 129 and all the way back at the start of the judgment in paragraph 15, when he found that we didn't know and that there was no reason why we ought to have known that he was a problem gambler. And I addressed you on those right at the start of my introductory remarks, and having found on the facts as he did, the judge was absolutely right to rely on that and to dispense with that part of the foundations for the alleged duty of care. And of course, what he does at the end of that judgment, at the end of 164, is he refers to, he quotes a little bit of Calvert 170, the bit that starts wholly unrealistic. And so that's logically impeccable and on its own sufficient. But then the judge does go on at 165 to deal with the actively managed sort of VIP manager receiving incentives point. He finds that could not have given rise to a voluntary assumption absent Betfair having known, or it being said they ought to have known, that he was a problem gambler. That's also logically impeccable in our submission. Once one strips out the
logically impeccable doesn't address the arguments we're now on. We're now on the argument as to whether there is a duty of care on the assumption that ground one has succeeded, and there was known to be a breach because he was known to be or likely to be a problem gambler.
Yes.
So it's
all right.
We're addressing whether there is a duty of care in negligence in those circumstances, i.e. owed to someone who is known to be a problem gambler.
Thank you for putting that point to me, because it allows me to say, in the first place, that for all the reasons you heard from Ms. Tulip, you should never get to that point. If you get to that point, the case should be on all fours with the Australian decision in Reynolds, which Mr. Justice Briggs described, and I showed you the relevant paragraphs. Simply because you know or ought to know someone's a problem gambler isn't enough to enliven a duty. The right place for enlivening a duty is the place on the spectrum where Mr. Justice Briggs puts the trigger point.
Yes, I was just putting this at a different point. You're relying on what the judge has said, but the judge's reasoning doesn't really meet the problem we're now addressing.
Yes, what I was trying to say is the problem you're now addressing shouldn't arise either, because if you accept Mr. Justice Briggs,
I understand.
Briggs,
I understand.
yeah.
It's just that's your argument, not rather than adopting the judge's.
Yes, absolutely. Absolutely. I mean, I think
And the judge deals with it, doesn't it? It's right on the basis that there wasn't a duty because knowledge wasn't established. So you don't get to stage one, which is it's the same point as we're on. I put to you a moment ago that ground two is academic. If you're right on ground one, then what he then does is to deal very shortly with what if there was a duty, whether there was breach or not, and he really then just deals with that on causation, doesn't he?
yes. Well, he also finds no. He also says
four short paragraphs, which presumably you're going to come on to.
I will do. Yes. In fact, let me. Sorry.
Sorry, can I just check I've understood exactly what's going on? 168, as I read it, is where the judge actually deals with deciding there's no duty even if there was knowledge. Does it very shortly. He says it's not proximate. Fair or reasonable.
Yes.
Those don't depend on knowledge, do they? That's
Yes.
Is that right? I mean, I think.
No, I think that is right. I think it is and in particular, the last sentence of 168 says this approach also accords with the approach in Calvert. I think that is a paragraph where the judge is essentially, amongst other things, he's adopting the reasoning of Mr. Justice Briggs on Calvert, which puts the emphasis on proximity. It puts the emphasis on autonomy. So I think we're now dealing with paragraph 172 to 173 of Calvert. It puts the emphasis on autonomy, and it says, well, look, even if you, yes, it is saying even if you know or ought to know problem gambler, still not sufficiently proximate. Something more would be required on the Mr. Justice Briggs view of the world. He refers to the statutory context in paragraph 166. He was absolutely right to do so. Section 24(8) of the Act, he construes correctly. I don't think it was suggested that he hasn't construed it correctly. It is inimical to a hostile to a claim for breach of statutory duty, but it's also hostile to a common law duty. I'm not saying that there are no sets of circumstances in which Section 24(8) won't be overridden, because circumstances may arise where the court finds a voluntary assumption of responsibility. But if one is looking at the matrix of factors, it is a factor which points against there being a duty. At the end of paragraph...
Mr. Colquhoun accepted that 24(8) was such that there would have to be something other than
Correct.
the breach of statutory duty.
Correct.
Which triggered the existence of duty of care.
Correct. I mean, Section 24(8) is particularly relevant in this case because the way in which this duty was said to have been breached was through the prism of the breaches of the LCCP. Yeah. And right at the end of 166, in the last three sentences, the judge makes a slightly wider point beyond merely 24(8). He says the Act entrusts matters of enforcement to a specialist regulator. It provides for no private right of redress. The statutory scheme is public in nature. Now that's shortly compressed, but I think what the judge is getting at, because I think this was the submission that we made to him at trial, is that quite apart from Section 24(8), in circumstances where the Act has bestowed enforcement of social responsibility obligations on the Commission as regulator, the private law should be very slow to interfere. And one of the things you saw yesterday was the suite of enforcement powers that the regulator has: so license, amendment, addition, suspension, revocation, financial penalty. It also has powers to enter into regulatory settlements under which it can direct payments to be made to victims. So the Commission is given these powers by Parliament, and any decision the Commission takes about which of those powers to use in any particular situation may be a delicate and a complex decision involving, amongst other things, a consideration of what will best promote the objects of the Act. That's the regulator's job.
Yeah.
But it is, I think, important to bear in mind that the blunt instrument of financial compensation may not be an appropriate or a completely appropriate response from situation to situation. Could I just show you something in the most recent white paper about that? It's at tab 51 of the third authorities bundle. And if we could go, please, to page 1726. This white paper, which begins at page 1718, amongst other things, recommended the establishment of an ombudsman for dispute resolution in respect of gambling disputes. That has yet to take place. But at 1726, this is the chapter which deals with dispute resolution. And there's an interesting paragraph 19, which is sidelined. Responses also highlighted that in order to prevent harm, new redress arrangements should be seen as upholding regulatory standards and supporting people presenting with legitimate complaints. If they are perceived as permitting risk-free gambling by providing a mechanism to subsequently recoup losses, this would risk reinforcing negative and harmful behaviours. Financial compensation, therefore, may not always be the most appropriate outcome. There needs to be a consideration of a range of possible outcomes of adjudication. So this was the same white paper which decided there should, or which rejected the idea there should be a claim for breach of statutory duty introduced into the Act. What it's come up with is an ombudsman scheme, but recognising that the ombudsman will have a range of options and that in some cases financial compensation will not be an appropriate option because it may actually work, the effect may be counterproductive from the point of view of promoting safer gambling, responsible gambling, and the objects of the Act. Again, that is another factor which I think is what the judge was alluding to in those last three sentences, which going into the mix cuts against the idea that there should be a duty of care, except perhaps in the most extreme of cases, as indicated by Mr. Justice Briggs. Mm-hmm. All right, so we say the judge's evaluative conclusion that there was no duty of care was logically impeccable. It was rooted in his findings of fact to which there can be no challenge. There was no inconsistency in his reasoning. There was no failure to take account of relevant matters, and his conclusion on duty should not be disturbed. And that's what I say about duty.
You don't rely on a Henderson and merit point or a non-Henderson and merit point that there's a contractual relationship, and if there's no breach of a contractual term, it cuts across the limitation clauses and so on to impose a duty.
That's interesting. There was a Henderson and merit point which I was going to mention under the heading of the actively managed point, on the basis that the case I had to answer was assuming the judge was right on knew or ought to know. Does the mere fact that this is an actively managed customer enliven a duty? The judge obviously said no, and I said that's absolutely right. And in that context, there is a Henderson and merit point, because perhaps I could just show you the relevant term. It's in the terms and conditions at further supplemental bundle. Page 65. So under in the middle of the page, there's a number 2 and a heading use of our services. And it's just the first paragraph. You understand that you may lose money on bets placed and accept that you're fully responsible for any such loss. You accept that under no circumstances will any amounts lost by you under any bet be recoverable from us. So if the case being put against me was that, you know, simply by providing you services like our actively managed service, we're assuming a responsibility, then the terms and conditions would contain an express disclaimer counter to that. And indeed, what the bit I've just read out is there's nothing unusual or onerous about that in the context of gambling. It's a statement of the obvious. The customer will be responsible for his losses. I think the debate that we then got into kind of wrapped up knowledge as well, my lord. And I think if on my submission that Mr. Justice Briggs has put the trigger point in the right place on the spectrum, I think at that place on the spectrum, I think the Henderson and Merit point would probably be given very short shrift. So in that sense, I don't rely on it. But if I'm dealing with different permutations, then there might be some worlds in which I did. I'm grateful. Breach, as you say, the judge dealt with this very shortly. There appear to be two elements of breach pursued in my learned friend's appeal skeleton. The first was by reference to the breaches of the LCCP, and if we're right on ground of appeal one, that has to go. Insofar as the claimant is arguing that the judge should have found that Betfair was negligent in failing to close his account, even if it didn't breach the LCCP, that argument goes nowhere. The LCCP or LCCP compliance would still be highly relevant to the question of breach. Mr. Gibson had no other evidence of expert evidence of industry standards which would support an argument that Betfair fell below a standard of care at the relevant time. And indeed, all the expert evidence of the trial was focused solely on the question of LCC breach.
I don't think this argument's put against you, is it? It's accepted that it's essential to succeed on ground one. In other words, that it's necessary to establish a breach of the LCCP. I didn't understood it to be argued that there could be a claim in negligence, or there was being pursued a claim in negligence, on the hypothesis that there was no breach of LCCP.
I'm grateful. I was typing because I just logged myself out of the system and been logged out of the system. Now I'm back. I'm grateful. Can I deal with causation? Can I deal with the legal principles first and the applicability or possibly non-applicability of the but-for test? The judge was plainly right to consider and apply the but-for test. Indeed, both sides invited him to consider it and make findings of fact in connection with it. He concluded, as you know, that but for Betfair's breach, Mr. Gibson
Would have bet.
yes. Sorry.
Elsewhere.
He would have bet elsewhere. Now, if my learned friend were right to say that you can ignore that factual finding as part of the causation analysis, the result would be remarkable, because the result would not be to restore Mr. Gibson as nearly as possible to the same position as he would have been in had there been no Betfair wrong. The result would be to make him significantly better off than the position he would have been in. Now, that's the wrong answer. Why is it the wrong answer? I think there are two analytical routes that get you there. Alternatives, or maybe they're just two sides of the same coin. The first one is the one that was being tested by my Lord Justice Popplewell yesterday, and it's a nature of harm, scope of duty analysis. Yeah. And that analysis, in my respectful submission, was reminiscent of the actual judgment of the Court of Appeal in Calvert. And what I'd like to do is to show you the Court of Appeal's decision in Calvert, which is at bundle 1 of the authorities, tab 18.
That's at the end of the bundle, isn't it?
Yes, it is. So I think we can go to page bundle hard copy page 588.
Yeah.
And in Opus, it's AU/18 /18, I think. 19, in fact, on Opus. Right, I think we can pick it up at paragraph 47. I was going to read through this, but if you'd prefer just to read it to yourselves, I can let you do that.
And should we read 47?
Yeah, could you read 47 and also 48, please?
Yeah.
Speaking for myself, I did have to read those paragraphs more than once, completely to get them. But they are, and I do urge you to reread them if you would. Taking their analysis and applying it to the facts of our case, I think the principles that you get from it are that Mr. Gibson's claim is a claim for financial loss arising as a result of problem gambling. That was the harm against which Betfair's alleged duty of care was to protect him. The scope of Betfair's duty was not to prevent Mr. Gibson from gambling at all, simply to go some way, those are the words that appear at the bottom of page 588, just below letter G, to go some way to controlling his gambling by preventing him from gambling with Betfair. In quantifying the loss which flows from Betfair's breach, it would be wrong to ignore other gambling losses which, as a result of his propensity to gamble, he would have sustained in any event, but which he did not in fact sustain because of Betfair's breach. And it would be wrong because that would be putting him in a better position than the position he would have been in. So I think that is one analysis. Gratefully adopt the reasoning of the Court of Appeal in Calvert. The second analytical route is the one I think which was being tested by the Chancellor yesterday.
Yeah.
And that is that what we're talking about here are substitute transactions. The losses he would have sustained gambling elsewhere are losses he did not in fact sustain. He did not in fact sustain them.
Because you were too busy losing the money with you.
Exactly. So that is, in other words, Betfair's breach saved him from incurring the losses elsewhere.
And isn't that how the judge put it?
I'm sure it is. Well, it didn't quite put it that way, but I'm sure it's what was.
Well, I think it's, yeah. I'm quite satisfied he would have gambled elsewhere and to the same extent. So the judge's thinking was exactly that, wasn't it?
Yes.
If he hadn't been betting with Betfair, he'd been betting with somebody else and he would have made the same losses.
Absolutely. He didn't make those losses because he was too busy betting at Betfair.
He'd have made the same losses elsewhere.
But when one is inquiring into the causal effect of Betfair's breach, you have to take account of the losses he made at Betfair, the gains he made at Betfair, and also the gain he made by not making losses somewhere else. Now, I don't think it's very surprising that on either of those analyses you get back to the same place.
Yeah.
Because the same place reflects the basic principle that he mustn't be put in a position where he's better off. And FCA and Arch wasn't developed before you yesterday, and it doesn't exist. So
with respect to Mr. Kulkarni's.
so that is the answer on causation as a matter of law.
Yeah.
In terms of the judge's findings of fact, I didn't apprehend. I mean, yesterday submissions were made on the basis that the judge had made a finding that he would have bet in other betting exchanges elsewhere. That isn't the limit of the judge's finding. And there was ample evidence before the judge that there were plenty of other places he could have bet, including betting exchanges, but not limited to betting exchanges. I mean, if I could just show you one passage of the evidence, that would be in the supplemental bundle at supplemental bundle 1 at bundle page 231 to 235. And the opus reference is SB4/2/4 and 5. So this is Mr. Rourke's second witness statement. That's not the right opus reference. The opus reference is SB4/2/4 to 5. But if my lords, you have hard copy pages 231 to 232. Could I ask you to read to yourself paragraphs 11 and 12, please?
Yeah.
So he could have placed bets with almost any bookmaker with a sports offering. That's paragraph 12. And then this was also an issue dealt with by Mr. Devlin. And in the bundle you're in at the moment, could I ask you to turn to page 358, please?
What's the opus reference?
The opus reference is SB4/11/3. Could I ask you to read paragraph 9, please?
Yeah.
So it's the bit at the end of paragraph 9 about the numerous online bookmakers would have offered and still do offer odds. That goes to availability of options. As to willingness to use them, as the judge said in the last sentence of paragraph 173 of the judgment, the best evidence was the fact that Mr. Gibson had actually done so after his Betfair account was closed in 2019 and 2020. And the judge analysed the details of his post-Betfair gambling at paragraphs 136 to 138, and he incurred losses in the hundreds of thousands in a very short period, 18-month period.
326,000 over a period of 22 months.
Yes, a bit more than that, I think. That is because there was also he
Yeah, sorry, 406,978.
Yes.
138.
I think there is in fact an arithmetical error in that number of 406,000, which none of the council team spotted when we were given the judgment in draft. I think it's just over 500,000 actually, and you get that by adding up all the figures in 137 and in 138.
Okay.
So very significant losses in a short space of time. Now, I think the challenge that was put yesterday, you were shown some of was actually on the proposition that if Mr. Gibson had gone to other bet makers or to other gambling operators, he would have been shut down by them without significant loss having been incurred, and that was the submission that was rejected by the judge at paragraph 174.
Yeah,
again,
the judge says rejected that.
Yes, I mean I think there were two elements to the judge's thinking. The first was that he had in fact racked up hundreds of thousands with other gambling operators.
Over quite a considerable period of time. In fact, when we looked at the time,
about 18 months.
Nearly 2 years.
Yes, yes. And the second was that the judge found that Mr. Gibson would have deceived those other gambling operators in exactly the same way that he did to us during the period when his account was open. Now, both those findings were open to the judge. You were told yesterday that BetDAC imposed a £1,000 a month deposit limit on Mr. Gibson, and that is true, but we checked the facts overnight, and that was not in fact imposed until the 16th of September 2020, which was some 18 months after he'd started betting with BetDAC, and by that stage he'd already lost 280,000. And in fact what then happened was he deposited a further 60,000 at BetDAC despite this 1,000 a month limit, because he used an account in the name of one of his friends.
Yeah.
And you were also taken to some evidence from Mr. Brown yesterday, where he said that if someone was staking £20,000 on a single score market, quotes, we would establish their bona fides very quickly. Mr. Brown was the director of operations from BetDAC. I mean, that doesn't go anywhere, because that simply means that they would have interacted with the customer.
Yeah.
And then you get back into the judge's finding about what would have happened. But can I just, last point on causation, factual causation, show you two passages of the evidence of Mr. Brown more generally. These are in two different places actually. So the first supplemental bundle at pages 251 to 252, and the opus reference is SB4/4/2 to 3. So this is paragraph. This was Mr. Brown's witness statement. In paragraph 8, he set out details of the total matched stake on the BetDAC exchange in the years 2015 through to 2020. The matched stake is a very different figure to the unmatched stake. We don't have the details for the BetDAC unmatched stake, but for Betfair, the unmatched stake is many multiples of the matched stake.
Yeah.
And so that was his evidence that based on the data summarised above, it's reasonable to.
Unmatched stake is just an unsuccessful attempt to bet. Is it?
That's right.
Yeah.
That's right.
Yeah.
And then in terms of his cross-examination, if we could look in the second supplemental bundle, pages 1 to, in fact it'll be forgive me, it's the third supplemental bundle, pages 1 to 94 and 1 to 95, please. the opus reference is SB6/13/16 and 17, please. So this is Mr. Brown's cross-examination, and if we look at the page, the top page on opus, line 11, or line 8, question. So how many football matches are there that are offered as correct score markets on the Betfair exchange per year? Answer, there are about 40,000 every year, and pretty much every single one of them will have a correct score market on them. And then if we look at the next page, or the next 2 pages, please, down at line 18, Mr. Brown says, all I can say is 40,000 is by far and away much greater than any other exchange other than Betfair. And pretty much all of those games are in play as well. So it's a substantial operation we run. And then the judge says, are you able to say, if given that you've covered 40,000 games, if there would always be football matches available on the system? He says, there is always, as a market, apologies, yes, there is always football games pretty much 24/7 available to play, yes.
Yeah.
That's all I was going to say on ground of appeal 2.
Mm-hmm.
And I turn to ground of appeal 3.
Yeah.
On the authorities, this is statutory illegality. I should say that the judge's reasoning is compressed at the end of his judgment, but it's comprehensive, and he was and he was correct. On the authorities, you were taken this morning to Phoenix and to Okadina. Could I take you to the case of Hughes, which is in the first authorities bundle, tab 13.
Yeah, this is the case that's referred to in Aberdeen, isn't it?
It is. You get a bit more by looking at the case itself.
Yeah, sure.
Yeah. So the case arose out of investments in October 1987, which from memory was a stock market crash month. And if we look at the head note, 5 lines down, the appellant brought proceedings against the respondents to recover the loss on the investments on the ground inter alia that although the respondent had been licensed to deal in securities under section 1 of the Act, the individual who'd made the signed agreements on behalf of the respondent didn't at the time hold a representative's license as required under section 11B of the Act, and that as a consequence the agreements were a nullity, since the Act, by prohibiting unlicensed persons from dealing in securities, rendered void any purported contract. And then the decision, have you probably read ahead, have you? I'm grateful. So one sees in the head note that claim was rejected. If we go to page, using the bundle numbering, page 415, we can see the terms of section 1 of the Act just at the bottom of that page by H. Could you read the terms of section 1 of the Act? So the prohibition was on carrying on or purporting to carry on the business of dealing in securities. And then if we turn over the page and go to page 417, and if we pick it up at B, Lord Justice Saville says, as a matter of pure construction, the language used by Parliament does not, to put it at its lowest, clearly indicate that the statute meant to prohibit, that is to say, make void, contracts made by unlicensed representatives, for the subsection prohibits such a representative both from making deals, which X hypothesized he couldn't do, and purported deals in securities. Indeed, as a matter of language, this could be said to indicate that Parliament was not seeking to render unlicensed dealings a nullity, said it was confining itself to imposing criminal sanctions on those who engage in the activity. And then he says by D, in this connection, there are 2 matters worthy of note. The first of these is the particular prohibition under discussion is not on its face directed against the deals themselves, but against the servant or agent making the deals, while the second is that the prohibition is not directed against either of the contracting parties to the deal. but to the agent of one of them. And there's an obvious analogy there with our situation, because we are a betting intermediary. We're an exchange. We facilitate gambling contracts between others, the willing layer and the willing backer. We are not parties to the contract itself.
No.
What Justice Saville is saying, that D applies specifically, because of the facts of that case, to contravention of subsection B of section 1.
Yes.
And wouldn't apply if it had been the entity itself.
Well, I think he would have
dealing in securities. And the analogy with this case is that Betfair is itself carrying on the activity as a betting intermediary, which is proscribed by the statute unless in accordance with the terms of its licence.
I'm not sure I do accept the steps in that analysis, my lord. I mean, the Lord Justice Saville expressed himself in the way he did because the particular issue in this case was the position of the representative, the agent, if you like, under 1.1b. But I think one can, the analysis would, I think my submission would be that the analysis of the court would have been the same if the position had been 1.1a, because the construction analysis is that the prohibition is against the activity of dealing in, it's not against the deals.
That's the point. I mean, the point he makes, which he begins to make at, I think, at letter F on page 673, so 417 of the bundle, is the broader point, isn't it? Which is that the mischief that the statute was directed at was the unlawful activity or the illegality of carrying on business without a license. It wasn't the transactions. It wasn't intended to strike down the transactions that were entered into, albeit entered into by somebody who was acting unlawfully because they didn't have a license. And that he goes on then to do the point that the effect of the contrary, which is the point that I was putting this morning to Mr. Kulkarni, to decide that the statute had the broader purpose, which it might have done, but if you're left with a choice as to what the statute is directed at, you have to bear in mind that one effect of what's being contended for by the claimant here is that both the guilty party and the innocent party suffer.
Yes.
That's the point that he picks up about Phoenix.
Exactly. I think where he begins to develop those ideas, my lord, and I completely agree with that analysis, if I may say so. I think he begins to develop this analysis, as you say, at sort of round about F, just below F. The case therefore stands at one remove, but also at J on page 673, where he begins to look at the consequences of the construction.
It's really the passage that's at B at 674, and particularly when he's dealt with Phoenix of Greece, the sentence beginning, in other words, the argument put forward by the appellants necessarily involves a proposition. Parliament has chosen to provide a defence against claims of breach of contract in favour of the very people who have ignored its licensing requirements. And then it goes on to say, in fact, I can't imagine why Parliament would ever want to do that.
Yes. So that's absolutely right, and I say that applies to us or to this situation just as much.
Is that right? Why, if you're a broker rather than direct, as all the right expression is in the gambling, you emphasise the fact that you're a broker. You're on either side of the contract.
Yes.
So why does it give you a defence?
Well, I think
someone else a defence.
Sorry, I spoke over you.
You might give someone else a defence, just not you. That's the bit I'm not understanding.
First, in case I've not understood properly, if we commit the offence in section 33, we're liable to be penalised. If on my learned friend's construction that section 33 impliedly prohibits contracts. If we, through providing facilities for gambling, produce a contract between a willing layer and a willing backer, on my learned friends construction, that contract would be void just as much as if we were actually taking a different role, which was being a counterparty to the bet. Now, I just think that actually makes the situation even more extremely unfair in our situation to the backer and to the winner of the bet, because his contract would be void through no fault of his own. Well, it's the same point.
Well, and Lord Justice Hurst in his short judgment picks up the same point. And I mean, goodness only knows it's many moons since I looked at Phoenix of Greece and Cavalier Insurance, but now I see them referred to, it all comes flooding back. But the point there was that he makes the point that it was because the statute itself prohibited the carrying out of the contracts of insurance. And I haven't looked at the Phoenix in detail, but my recollection now, as the judge says here, is that Lord Justice Carr reached that conclusion because he had to, but he reached it with the utmost reluctance. Because it really wasn't, well, he ended up in a situation where the innocent party suffered as well as the guilty party.
That's absolutely right.
And he's making the point here, well, you shouldn't really reach that conclusion unless you absolutely have to.
Yes, that's absolutely right.
But
And
to develop my Lord Justice Birss's point, are we dealing with a single contract? If you are matching bets, you've got contracts with two different people in relation to a given bet.
yes,
And the rendering void of the contract with the loser may involve you losing your commission, but does that necessarily render void also the contract with the successful counterparty who has, let us suppose, laid the bet?
well, I think that's the.
Why should it?
Well,
It's not the same contract. Is the point?
My submission is that it shouldn't. I mean, none of this should be happening because Section 33 contains no implied prohibition on the contracts, on the bets.
No, but the point we're on is, if it's a single contract, it punishes the innocent as much as the guilty, and that's
Yes.
a reason for not for not
The
treating that
contract.
contract as void ab initio to the
Yes.
detrimental benefit of both parties. But if we're dealing with two separate contracts, and it is only the innocent who are protected.
Well, I think the right contractual analysis here is that Betfair and Mr. Gibson entered into a framework contract in 2011 when the relationship started.
That may be so, but then there'll equally be a framework contract with Mr. or Mrs. X, who under that laid the bet, which on the particular occasion resulted in losses to Mr. Gibson.
Yes,
Assuming he was placing.
as between Mr. Gibson and Mr. X, there is a separate contract, which is the gambling contract. The corollary of my learned friend's submission that Section 33 impliedly prohibits contracts entered into through the provision of facilities for gambling must mean that contract, the gambling contract between Mr. Gibson and Mr. X, is also void. Forget Mr. Gibson, just Mr. X and Mr. Y.
Maybe so, right? We might need to look a little bit more carefully at that.
Can I show you? Can I show you Section 5 of the Act, which we've not yet seen? Section 33 prohibits the provision of facilities for gambling. Section 5 of the Act which is at page 3 of the authorities bundle in tab 1. Defines facilities for gambling. 1, for the purposes of this Act, a person provides facilities for gambling if he invites others to gamble in accordance with arrangements made by him, provides, operates, or administers arrangements for gambling by others, or participates in the operation or administration of gambling by others. So you can provide facilities for gambling in a number of ways. B covers the position of a betting intermediary. The word arrangements has all the appearance of a word deliberately chosen to avoid getting into the question of contracts. And if one then comes back to section 33, which is at page 22, a person commits an offence if he provides facilities for gambling. I mean, again, there's just that there is no necessary or implicit prohibition of contracts there at all. What is happening is the penalising of an activity carried out in a particular way. So that's just on the
It's a penalisation for running the on this hypothesis, penalisation for running the exchange,
providing the facilities.
providing the facilities without complying with the terms of the licence,
That's right.
which you would say has got absolutely nothing whatsoever to do with what contracts may be made.
Making void contracts.
on the exchange.
That's right. So that's what I say, just looking at section 33, but then you have to look slightly wider. You've got section 24.8.
Yeah.
A failure to comply with the provision of the code shall not of itself make a person liable to civil proceedings. That's inconsistent with Malone and Friends case. You've also got the sections that Malone and Friends showed you right at the end of the Act. So can we turn forward to section 335 and 336? Can I just deal with 335 first? I mean, that is saying that this is at page 94 and 95. That is saying that unlawfulness that would otherwise relate to gambling shall not render the gambling contract void. That's, in my respectful submission, hostile to Malone and Friends case. Section 336, the power of the Gambling Commission to void the bet. The point here is that section 336 it shows that Parliament turned its mind to circumstances in which bets should be void. And the particular circumstance in 336 is substantially unfair bets. But that's not really relevant. It's the
Gambling Commission. Left that to the Gambling Commission.
Yes, exactly. Yes, but it did consider the question of whether
sure.
bets should be void. And when it thought they should,
It very limited. It said only in very limited circumstances.
Exactly, and it expressly spelt it out.
Yeah.
And then there's a third point about the Act generally, which is more about the architecture of the Act as a whole, which is that, as we saw, the Act established this comprehensive regulatory regime, and it bestowed its wide enforcement powers on the Commission. And it's for the Commission to deploy, the warnings, the licence amendments, suspension, the revocation, etc. Right. And if the Act had been silent on the issue of sanctions, that might be one thing. But the Act considers, makes express provision for a host of sanctions, and that approach is comprehensive, and that just sort of leaves no space for the idea that Parliament, on top of all of that, also impliedly intended section 33 to prohibit contracts. Now, then one gets into the issue of policy reasons. If Mr. Gibson were right, section 33 would operate to invalidate all bets placed by a customer, and that would produce indiscriminate and unsatisfactory consequences. As the judge put it in 181, a successful gambler should not be deprived of the fruits of his bet. That's unsatisfactory consequence 1. Equally, as the judge put it, a losing gambler should not be entitled to escape the consequences of his decisions, especially in a situation where the particular reason why the licence condition were breached might have had absolutely nothing to do with that customer. I mean, just to give you one example of that, could we look please at the first supplemental bundle at page 119. So this is Social Responsibility Code provision 3.1.1. We looked at paragraph 1 yesterday, but just to show you paragraph 2, which is also an SRC provision, licensees must make an annual financial contribution to one or more organisations which between them research into the prevention and treatment of gambling-related harm. And just imagine for a moment that Betfair had not made its annual contribution, perhaps because there was an administrative mistake in the payments department. On my learned friends analysis, all the transactions, well, the contracts, he says contracts, I say contract, would be void. I mean, that's a preposterous result. You could have the most trivial license breach, anything to do with particular bettors or players, and on that basis, all would be set aside. It could, in fact, have an absolutely disastrous effect for the industry, and that's the point the judge makes about the industry being thrown into chaos if this were right. And it's very unlikely that Parliament could have intended that as a consequence, because one of the whole points of the Gambling Act was the development of a successful and thriving gambling industry, employing thousands, and one can see that in the original white paper. So if you still have, no, in fact that's Authorities Bundle 3, tab 49, at page 1538, opus page 4. My learned friend took you to the sidebarred passage yesterday, but actually we skipped over the sentence that begins in the middle. We also, however, want to see a successful British gambling industry, one that's able to respond rapidly and effectively to technological and customer-led developments in both the domestic and global marketplace, building on its existing reputation for quality and integrity. And then if we just turn forward to page 1565, which is opus page 31. The first paragraph, in the government's view, the law should no longer incorporate or reflect any assumption that gambling is an activity which is objectionable and which people should have no encouragement to pursue. It's an important industry in its own right, meeting the legitimate desires of many millions of people and providing many thousands of jobs. So, unless Parliament actually spelt it out in terms, it's very unlikely that they could have intended by Section 33 a consequence which could be absolutely chaotic for the industry.
And although it's understandable that they don't expressly say this, producing very large tax revenues for the government.
That is a fact.
And that's no doubt part of the policy behind the legislation.
I am sure that it is. So for all those reasons, I say the construction of Section 33, for which my learned friend contend, is wrong, that the judge was right, that it is not necessary to imply a prohibition of contracts into Section 33. It is not clear that it should be, and it would have the most wide-ranging and very unsatisfactory results if that had been the result intended. And that was all I was proposing to say about ground of appeal 3, except of course to make the obvious point that if we're right about ground of appeal 1, you don't get to ground of appeal 3. Unless I could help you any further.
No, thank you very much, Mr. Davis, James. Yes, Mr.
My Lords, before I start, inspired slightly by my own friends, Mr. Mitchell wishes to say 2 or 3 minutes about how betting exchanges work, just to answer some of the questions from the bench while my own friend was making his submissions, and then I will follow in after him.
My Lords, I'm just going to address you very briefly on 3 factual points about how the exchange works, because it may assist you with the contractual analysis that will sit behind the duty of care point and also the void contracts point. So the first point is how the contracts operate on the exchange. So when customer A wishes to risk some money on a bet, Betfair will reduce their available to bet balance by the amount that they have agreed to risk. That then goes into a pool of people who want to back or lay an event at certain odds and is available for somebody else, another customer, customer B, to choose to take up either on the back or the lay side. When customer B chooses to take that up, Betfair reduce their available to bet balance by the amount that they wish to risk. So on the backing side, you normally have a lower amount, say £1. On the laying side, you might have a higher amount, say £10. And then that's complicated by the fact that you may have 10s or 20 of people in each pot who want to back at that odds or lay at those odds. So you have many, many contracts that are going on, but in my submission, they're all between Betfair and customer A or Betfair and customer B. So in other words, if customer A agrees to risk a certain amount of money in return for certain odds and they lose, then Betfair will take that money and then they will pay it out to the winner. But the contractual obligation is always owed with Betfair, such that you're looking at distinct and separate contracts, not all of which may be void. So the second point, which is allied to that,
But not a contract between the punter who backs and the punter who lays.
no
Mr.
direct.
suggesting.
My suggestion is there's no direct contact. There's no contact at all, and there is no customer A and customer B, because in reality, each side of that bet is split into many parts ordinarily, because you might have hundreds of people that are all backing Man United on a certain correct score, and then they're matched with the computer program with other people who are laying. So there just is no direct contractual relationship between customer A and customer B in my submission. The second point is that commission is paid by the losing party. So in transferring the losing party's money is going to Betfair. Betfair is paying out some of it to the winner, but they're keeping the commission. So they are keeping the money that has originated from the loser. And then the third...
Is that commission in fact derived simply from the spread between the bet and the lay odds that are displayed?
No, it's a percentage.
Charge?
It's a separate percentage charge, which is actually a percentage which is part of the agreement between the winning customer and Betfair as to what percentage commission rate they're going to be on. But the money is coming from the loser. The winner receives less than all of the loser's money, and the remainder goes to Betfair. And then the final point is just a conceptual point, but I would urge you that it is important when you're looking at duty of care, which is that if you make the assumption that all customers are equal skill at betting, then over time all of the money flows to Betfair. And I can illustrate that by, imagine, if you'll indulge me for a second, that perhaps I have a game with the bench where we flip a coin and we pay each other £10 depending on whether it's heads or tails. That's a game of equal chance. And if we're paying 1 penny out of our £10 to bet, if we do that enough times, then all of our money will end up with Betfair. And so although it seems like it's a small amount of commission in respect of each bet, of course if you take that, I say relatively logical assumption that customers of roughly equal ability in betting, you see that this is why you may have a situation where most people over time lose money on the exchange, because the money is flowing to Betfair via the commission. It's much easier to see that point with fixed odds games like casino games or blackjack, which of course are just as much going to fall within your lordship's decision in this case. But in those games, let's say blackjack, is a fixed odds which benefits the casino operator. So the more you do it, the more you lose. But actually conceptually, I would suggest to you there's no real difference with the exchange. I think I'll only see the leading counsel will show you some data about the number of people that lose on the exchange compared to the tiny minority of people that win any significant money. My lords, unless you have any questions, that's all I was going to say.
My lords, I shall be brief. I'm going to deal in turn with my learned friend's submissions on grounds 1, 2 and then 3, very briefly. On ground 1, my learned friend Tulip made some submissions about my case on paragraph 3.4.1 of the code. Now, I was not suggesting, and if I had created that impression. That was the wrong impression. I'm not suggesting you don't need to have a policy until you have a concern that a customer behaviour may indicate problem gambling. I would agree that one needs to have policies in place, and they must include the A to F of that provision. And that is because where you then have a concern that a customer's behaviour may indicate problem gambling, the policies are put into effect, as it says, so as to deliver the effective customer interaction. And so then the separate question becomes, what is an effective customer interaction when you get to the point in time where you consider your customer is likely to be a problem gambler? And my submission is that involves either setting a limit, if you have the information to know what kind of limit you can set, and if you don't, you can't reliably obtain that information, you should refuse service. Now, my lords, I repeat the submission I made the first time round, that Betfair's policies don't give any consideration to refusing service in a final sense, the sense of ending the customer relationship. And I don't accept suspension is the same as refusing service, because where one sees refusing service in the code, it's little c. There's a finality to it, so I'm not going to take your lordship to it now, but it refers to refusing service and or barring them from the operator's gambling premises. So there's a finality to that, to little c, and what one has to consider is the prospect of ending that current relationship, refusing service, barring from premises if you're operating out of a shop, and so
it can only be permanent.
it can. I submit that can only be
For the
permanent.
lifetime of the. So you can't come back 20 years later and say, "Can I come back into William Hill now?"
Well, my lord,
Really?
I can only go on what the provision says. The provision says refusing and or barring from the premises. It may be that if somebody can come back after a period of time and persuade the operator that they are a changed person. How they do that, I don't know. But there may be scope. But in terms of
That barring doesn't necessarily mean permanent barring, which is the point that's put against you. Exclusion doesn't necessarily mean permanent exclusion.
well, my lord, as against that, all I would submit is that the Gambling Commission documents I took you to do appear to have a spectrum where they ratchet up to an eventual ceasing of customer relationship, and that tends to be treated as synonymous with refusing service. So that's how I put that submission, my lord. And I submit my own friend's very light touch that she suggested subparagraph C of 3.4.1 had is untenable. It can't be sufficient that one simply gives consideration to refusing service, and the consideration is we've decided we're never going to refuse service, and thereby you've complied with the policy. It runs contrary to everything the Gambling Commission was saying from well before the LCCP were entered into. And she showed you in her submissions a diagram. I won't take it to you, but it's on the supplementary bundle at page 22. Now, that does have a box that refers to exclusion enforced, but my lords, that seems to be something of an aberration in all the policies. It does have that box, but it's not set out in the substance of the policies. There's no route set out for how one gets there. And that the question of whether the policies not containing a refusal of service aspect was put to the witnesses as a deficiency is in the handout that was handed up to your lordship earlier today by the start of the day, Mr. Mitchell's handout. I don't say anything more on ground one other than that I maintain my earlier submissions as to the respects in which the judge's conclusion was incoherent. On ground two, I should try to be brief here. To whom is the duty owed? It's owed to a problem gambler. And I would say one uses the definition in the judgment as to what a problem gambler is. Now, one should have, there's been much debate as to, well, where are the boundaries of that? It can be difficult to pin down the boundaries. But in response to that, I submit, it's a definition, the term problem gambler has been clear enough for the Gambling Commission to set it out in its codes of practice. It's been clear enough for the Gambling Commission to prosecute what it perceives to be breaches of the codes in that respect, when customers have gambled when it's unaffordable. And your lordships will recall I took you to some notes, one of which, the guidance note of July 2019, so it's S page 142, contains reference to enforcement steps being taken. So it's a concept that's clear enough for the Gambling Commission to set out in its codes and to enforce. And I submit there's no difficulty in principle of fashioning a common law duty in the same way. I mean, perhaps the most pointed criticism of why one would not impose a duty, my learned friend's most pointed criticism is the difficulty in identifying a problem gambler from data. How does one do it? And my lords, I submit that that concern is answered by modern technology and software. And in that regard, I repeat the references in the Gambling Commission documents I showed you, Professor O'Sullivan's article. Fundamentally, it's the same data that is used to tailor inducements and generate profit that can be used, that the operator can use to assess whether the customer is exhibiting the type of gambling behaviour that would require protection, is how it's described in the document. Now, working out that this is a customer that may need protection is, my lords, precisely the kind of inquiry that one engages when you work out whether they're a problem gambler. Now, my learned friend said in his submissions that there was an implicit acknowledgement that the technology today is pretty sophisticated. But he said, well, we can't speak for how the position would have been in 2015, 2019. And the best we have on that for that is the judge's assessment. Now, there is a document, my lords, that it was in the trial bundle. It's not in the appeal bundle, but if I could just bring it up, Opus will have it. Opus could bring it up. It's bundle G11 from the trial bundles. G11 tab 233, page 4. And this is a gamble-aware remote gambling research from August 2017. And the only point I draw your attention to, my lords, is the third paragraph states says key messages from a phase 2 study. Third paragraph starts, for the phase 2 study, we surveyed over 160,000 UK-based customers from 4 large remote gambling operators to identify problem gamblers using the PGI screen, supplemented by various other things. And if one goes to the first bullet, so using behavioral analytics techniques, they say the remote gambling industry could accurately detect problem gamblers using data held by operators today, with a refined set of 22 predictive markers used to create a customer-specific risk score. So the real challenge to trying to impose a duty, which is how do you identify a problem gambler, in my submission, that is in large part answered by the way in which the world has changed. Sorry, and also 5 bullets down, a risk score can be calculated within 1 week of transactional data. And so the point is, it doesn't actually take that long either. So my lords, I submit there should be in principle, no problem with fashioning a duty by reference to the class of problem gambler. And while there may be argument around the periphery of that class, as with the debate that happened between the bench and the bar about knowledge, where there is doubt, you deal with that in a case, and if the person doesn't fall within the class, well, there's no duty owed. But that is not, the periphery is not a reason not to impose a duty or create a duty to protect those that, in my submission, deserve common law's protection. By whom is the duty owed? Well, it's owed by an operator or an exchange who knows or should know that the person is a problem gambler, and by a person who actively manages the particular gambler. So just taking each of those, know or ought to have known. Now, my learned friends took issue with the second part of that, or ought to have known. He suggested it should be more like some sort of equitable duty where your conscience is in some way impacted before you can impose duty. I submit ought to have known is exactly right, because what it's saying is either you know, but if you don't know but a reasonable person in your position would know, well, you can't escape your ignorance in that case. And that is entirely fair for imposing a duty in these circumstances. And my learned friend's argument against the duty in these circumstances was in part identifying problem gambler, but then also where do you place the trigger? And there was a debate as to how close to obvious loss of self-control you have to go before the trigger lands. But our formulation placed the trigger on knowledge, when you know or should have known someone's a problem gambler. That may be something that's open to argument, but it's, in terms of principle, it's a clear trigger. And the second part of our formulation, so we're not suggesting this duty is owed to all problem gamblers. It's owed to those you actively manage. And what does that mean? That means circumstances where you're individualizing your inducement of their betting. So that's either by personal management through a VIP team, or exploitation by use of individual level betting data to target that particular person. So if you are using that information and you are effectively tailoring, incentivizing them on a very personal level, in my submission, that changes the analysis. And what does the obligation involve? It is an obligation to take reasonable care that further provision of gambling services will not cause harm. Where the harm's financial, that reasonable care may require setting deposit limits, if you can determine the limits, else refuse service if you can't. And in terms of my learned friend's position on the duty, one ends up in a wholly unattractive place. Essentially, it comes to, if there were ever a duty owed, it would only be owed to those with the most extreme loss of self-control. But those individuals could never have a claim, because they'd always fail at the causation hurdle. So that cannot, in my submission, be a fair or correct analysis. And the last ground, my lords, void contracts. I thought about Lord Justice Popplewell's point, tried to at least, and the point, as I understood it, was if an operator unscrupulously declines to have an operating license or maintain any policies in accordance with the LCCP, it would mean that in principle, if that contract were then voided, they could then rely on it to refuse to pay out on gambling contracts with anyone. And public policy cannot be in favour of that. Now, my lords, in that event, yes, that is correct. That would be the outcome. But I submit that is a commercially highly unlikely scenario. The idea that an operator refuses to pay out on bets on the basis they don't have an operating license or don't comply with the terms on it is an operator that won't remain in business for long. Their repeat business will not come back to them. And the flip side, and that is looking at a very small section of the market. The flip side is you have unscrupulous operators who don't obtain their operating licenses, who actively ignore their conditions. They can keep their customers' money when they shouldn't be in business at all. They shouldn't be contracting. And the point that Mr. Mitchell made a moment ago is the statistics show that the people that make money out of gambling are gambling operators, by and large. And the document I was going to bring up for you, it's in bundle S7, page 6, so S1442. And it's once the entries on the left-hand side show.
Hang on, we haven't got it.
I'm not sure I understand your reference, I'm afraid. S7.
This is a trial bundle.
This is a trial. No, my lords. This is the appeal bundle. The supplementary appeal bundle.
Yes. Supplementary appeal bundle, page 40.
What's
the hard copy page number?
It's S7, and it's page 1442.
1442.
What's the focus number?
S7 tab 6 page. S7 tab 6 page. You have to go back page 1. Page 2.
This is it, my lords, on the screen.
Okay.
And so everything red and down is where the customers win, and everything from amber up is where the customers lose. So and unsurprisingly, the majority of wins and losses are within sort of fairly modest amounts. When you start getting to the higher amount, it tapers off on both sides. So I was rendering an offending contract void would mean the preponderance of customers that shouldn't have had to enter into those contracts will avoid their losses, and that is the I submit that is the likelihood of whatever would happen. And when one's talking about policy, my lords, I submit that policy shouldn't be shaped by the fringes or by what I accept the example given by Lord Justice Popplewell. Yes, it doesn't feel like a particularly just outcome, but in my submission, it's a commercially unlikely situation, and one should shape policy by reference to what is the more likely situation. And the only other point I'd make on this, my lords, is that the protections afforded to the customer, and the reason why I submit that the intention behind the Gambling Act, the policy behind the Gambling Act is supported by voiding those contracts, is that protections afforded to the customer in commercial gambling situations are the safeguards and conditions required by the Act. If you allow betting operators and exchanges to provide their services without safeguards and conditions, you allow those contracts to remain valid, one is depriving the customer of the protections intended by the Act and allowing the operator to make profits when they should not have done so. And so I submit that voiding the contract does give into effect to that intention. And to address the bench's point as to, well, injustice falls on both sides if you void a contract. Here, I submit the vast majority of the injustice falls entirely on the customer if you don't void the contract. My lords, unless I can assist further, that's all I was going to.
No, thank you very much. Just one point. Nobody's really addressed us on contributing negligence and limitation. If we were to get there, what do you suggest we do with them? Do you want us to deal with it on paper, or do you want to reserve a position to make further submissions, or should we remit it to the judge, or what?
I think both those. I think that arises on my respondent's notice.
I think it does,
I'm
yes.
grateful that that's been raised. I think it would be possible to make some very short submissions in writing if you were to.
Well, let's leave it on that basis, and it can do dealt as a consequential, depending on the result of the judgment. Okay. Right. Well, we thank you all very much for your interesting and helpful submissions. We'll obviously reserve judgment. We'll let you have a draft judgment as soon as we can. In the usual way, that's simply to notify the court of any typographical errors, not to invite the court to reconsider its decision if you don't like it. Could you please pay attention to the terms of the embargo and make sure that they aren't breached? You may know there have been a few relatively high-profile incidents of the embargo being breached in the recent past. So just be careful of that. But once again, thank you very much indeed.
Court advisor table.